negligence is landowner liability. If we've got people coming on the property, landowner liability is just how do we look at it from a negligence standpoint? What duty of care do we owe them by them coming on the property? We're going to really talk about three forms of this today.
Well, welcome. This is our monthly installment of our Land and Wildlife Speaker Series. We cover all different topics, and I'm excited today to have Paul Goeringer join us. Paul Goeringer, he's going to speak with us about landowner liability for hunting in Maryland. A lot of landowners I know might have some concerns. They might not want to allow hunting because they're concerned about liability. Paul Goeringer is our principal faculty specialist here at University of Maryland Extension. Thank you for joining us, Paul. Welcome.
Thank you for having me today. So yeah, we'll go ahead and get started. So thank you all for joining today to learn about hunting liability. University programs are open to all, and you probably will not.
This institution is an equal opportunity provider.
Like Luke said, I'm with the Ag Law Education Initiative. You can find all our information at umaglaw.org. We're on Facebook, Instagram, and LinkedIn. Just search for University of Maryland Ag Law Education Initiative on all three platforms, and you'll find us. And our coordinator, Kristen Redding, does a great job at keeping things updated and getting pictures out and promoting events and publications. So if you have questions there, I'm going to skip all that. None of this is legal advice. I'm glad we're all good with that. And the first thing I'm going to talk about is with this, a lot of it I'm going to focus in on sort of Maryland specifically. With negligence law, if you're in other states, we can talk a little bit generally how it would operate differently in your states, because Maryland and Virginia sort of have similar principles, but after we get past those two states, they vary a little bit, and we can talk about that. If you got questions, just put them in the question and answer. Okay, so with hunting liability and a lot of what we're going to talk about, it's all related to negligence. And negligence is this idea in the law to where you fail to exercise a duty of care that we would expect a person to take on in those circumstances. It's also defined sometimes as the failure to act as what we would expect a reasonable and prudent person to do in those situations. Oh, and apparently the chat is disabled. I'm seeing from the questions, Luke. So yeah, this reasonable and prudent person really doesn't exist. They're just how we expect people to operate in circumstances. My example here, after what happened to me a couple of weeks ago, has been I was in an auto accident about 3 weeks ago. Now I'm going to explain what happened in the auto accident. I'm sitting on the Beltway, the Washington Beltway, waiting on an accident while it's pouring down rain for traffic to move, and my car got rear-ended. We all moved to the other side of the road, and there was no damage to either of our vehicles. We got lucky that day. We really don't have a negligence case. But as you're driving down the road, think about what do you expect people to do in those situations? Do you expect them to follow, whatever the conditions require, whatever happens in that situation, to be following at least somewhat of the speed limit, driving, using blinkers and other things? So in a lot of cases, what we're thinking about is just what do we expect people to normally do in those circumstances? And we can talk about that as we get through some hunting issues. So the elements, and we're not going to go through all these. You're not in my undergrad class where we spend like 2 weeks going through all these elements. We're going to have at some point, a duty of care is required to be done under these circumstances to the person that was injured. That duty of care was breached by the person who caused the injury. That breach was a proximate cause of the injury. And what proximate cause means is at some point, so some accidents are so weird, so unforeseen, everything that's going to happen in that, we're going to cut liability off at some point just because of the facts that the causal chain that created the accident created something that's so unique that there's no way to anticipate it would ever happen in that situation. And then in the end, we need actual damages, which is typically we need monetary damages associated with this that we can make people whole. Courts really can't go through and do anything else other than look at what it costs to either for the injuries to you or to your property to be able to reimburse other people for for those injuries. So duty of care, just something that the law recognizes and affects to conform to a particular standard. So we go back to my, driving on the road, what do we expect people to do in that situation? Follow the traffic laws, operate their vehicle reasonably for whatever the conditions do. And then we look to the relationship to determine if it exists. So we'll talk in a little bit, if there are people coming on as customers, you're leasing hunting out, that maybe it's going to be a little bit higher of a standard than what we normally would expect other people to have to follow through on. And if we can't determine there was a duty of care, there's no negligence. We don't go on past that. So with that, with the breach, then we define it as, once we figured out what that duty of care is, we have to figure out if there's been a breach. Did the person that caused the injury do something outside the norm of what we would expect a normal person to do in that situation to create that situation, to create that event to happen? It's, as I always point out, the reasonable and prudent person standard that we're thinking about in this, it's really not in a person that exists. They're this hypothetical person that we're going to do it. If you end up in one of these cases, your side's going to argue everything you did is what we would expect a person to do. The other side's going to say, oh no, you should have done all these other things that would have kept them safe. And, juries and judges will figure out what is actually at play. And I need to click back in the PowerPoint to make this work. Then with proximate cause, this is just the event, the cause that directly produced an event, and without the event, that would not have occurred. The famous case out of this is Paul's graph, and I think I go through the facts of Paul's graph on the next case, on the next slide. So I'll talk about this. This is where we come up with this idea. We have a gentleman running down to catch the Long Island Railroad in the 1920s to go home one day. As he's doing this, the train's moving. He appears to be following. Two employees, one on the platform and one on the train itself, help him get on the train. In the process of doing this, he has a package under his arm that contains fireworks. And that fireworks causes an explosion, which then leads to an explosion when it falls under the train track or under the train wheels, which leads to a shock wave, which eventually causes a penny scale to fall off the top shelf and hit Mrs. Paul's graph, a customer of the Long Island Railroad, on the head. Is this something we would normally expect? Well, the court's opinion in this was basically there was no way to guard against this. They had no idea what was in the package. They couldn't have done anything from the train side to actually protect you from this situation. It just appeared to be a normal package when it happened. And that with whatever happened because of that, there was no reasonable foreseeability that this would cause an explosion and then lead to this. The basic takeaway, as I always point out to people, is sometimes accidents are just going to be so weird and we don't know how to anticipate them. There's no way to anticipate that the package was actually going to be, some sort of explosive device that could then lead to this, that we're not going to be able to find liability for folks and help create issues. As historical records have shown later, this unfortunate woman had huge problems in her life where she couldn't leave her house after that. She was so scared. But because of just the unforeseeability of what happened there and it not being foreseeable, she can't recollect. And if you got any questions, we can talk about it later in the question and answers. But the idea is basically this is never an easy question to answer. Juries are really going to be the ones that decide this. And we'll talk about strategies at the end that kind of help limit some of this liability and help protect you better in the long run. And then in the end, we have the actual damages. This is just any economic loss we can put on it, whatever, lost property, repairs, medical expenses, things that can go into this. Anything that reduces your quality of life that we can put a dollar amount on. If something happens and we have to have future medical expenses out of it, we can do that, but we'll discount it to the present rate and expect you to invest the money in some sort of investment fund to be able to pay off future medical expenses as they come available. Okay, now we're going to get to the Maryland specific part of this idea of contributory negligence. So we are one of 4 states. The other 3 states are Virginia, North Carolina, and Alabama, and along with the District of Columbia. They all recognize this idea of contributory negligence. And for the other 46 states I didn't name off in this, they would have recognized this at some point, but they've switched to another negligence standard, and I can talk about that on the last slide when we kind of get to the end of this. The idea behind contributory negligence is we also have to look at what the plaintiff did in this, the injured person in all of this. What part did they play in causing the accident themselves? So we go back to my auto accident example that involved me. I'm just sitting there waiting on traffic, but what happens if it's not the situation where I'm waiting on traffic to move? I'm playing on my phone as I drive down the road, not paying attention. Someone rear ends me. Am I also at fault because I'm not actually following the rules as well? So the idea here is you're in the best situations at times to protect yourself. So what did you do to help limit your own exposure to risk? Does that make sense so far to everybody? I love doing this on Zoom because then none of you can really show me any facial reactions at any point. I've got Luke giving me a thumbs up. But none of this makes sense. We can talk about in question and answers. So like I said, the idea here is, were you the actual cause of your own injury? What did you do that played a part in all of this? And we look at it through the same lens. We start changing it around to go, did that person cause their own accident in some way? And before I get to assumption of the risk, we'll talk real briefly. The other negligence standard is comparative negligence. And in all other states, we just start weighing the fault of both parties, and then we just reduce the award. And I forgot to point one thing out here. If anybody wants to know what this standard is, in Maryland and in most states, if you're at least 1% at fault, you don't collect. You are barred from recovery. And in most accidents, we can often show that the other party was at least 1% at fault. The Maryland Supreme Court has said in multiple court opinions they will never take us off this standard. The General Assembly has to do it. So the General Assembly has to do something, and at this point, they have really put forward no bills to actually take us off this standard a little bit. With comparative negligence, we weigh the faults, and if the plaintiff's 51% or more at fault, they don't collect. But anything below 50%, we just start deducting from whatever the injury reward is based off that percentage. That's what the plaintiff collects. So it's a little bit more fair of a standard in comparative negligence, but that's where we're at in the state. Virginia is similar. North Carolina is similar. All other states, you have a different standard. Within this, one of the defenses, and the reason I bring it up with this is hunting. Is, as we're going to talk, a lot of what you can do with hunting liability is just start either from the fact that they have been hunters for years and they understand the risk, or we can start presenting what the risks are to them and make sure they're understanding them associated with whatever they're doing on the property in the form of hunting. So the idea behind this is, and this is a defense to a negligence claim, the idea is basically the injured person, the plaintiff, voluntarily consented either through signing a waiver or just from their own actual knowledge of the risks. That's what implied means. You know what the risks are from doing this, that you can then go in and you're exposed to this known risk. You later can't sue for the damages that you incurred because you accepted a risk. I use Wile E. Coyote flying through the air. You're in a suit like this. You know some of the risk associated with this. If you're in a wingsuit flying through the air, parachuting, there's a risk associated with this that you're made aware of ahead of time and told what the consequences could be if stuff goes wrong and you continue to confront the risk. Then we can't have injury later. And I see there's a question, and I will go to that question at the end because it will take me way too long to answer it right now. Okay, so like I said, express risk, you typically sign a liability waiver. There's some limitations to that in the state right now. If you're a commercial recreational facility, your ability to utilize waivers has been severely limited last year by the General Assembly. There are still ways to utilize those, and what I've been encouraging folks to do is work with an attorney. We do have a form liability waiver on the website, and I can send it to Luke at the end. Even if you use that, you still want to talk to an attorney about making sure it clearly reflects what you're doing and works for your situation. So like I say, if you go skydiving, you're going to sign a waiver that clearly states all the risk associated with it. Implied, we look at the relationship between the parties and what they impliedly agree to by assuming the known risk. So if we're doing with a hunting lease situation, for the most part, we're looking at the relationships and then what did the plaintiff know by entering into this relationship, what the risk would be associated with that, and what they would not be. Hopefully that all makes sense. So yeah, so with hunting, we can simply just put down a list of known risk associated with it. There's potential for, injuries while we're out there. Here are the known risks. Here are the types of injuries we normally would expect. We can get them to sign it. Again, as I said before, if we're going to go down this rabbit hole, make sure work with an attorney to make sure you're not within the commercial recreational facility requirements of the law. It's not, to me, entirely clear what qualifies as a commercial recreational facility. They did a great job of defining it in the statute. Get the party to sign it, acknowledging that they've seen it. I'm like, yeah. And go to the next one. I love when questions keep coming in. The other thing, as I kind of pointed out, we can utilize liability waivers with this. This is just a contract that releases the party from any liability that the injured party may have happened to them. Typically used with activities we know will lead to injury, skydiving. If anybody here signed up for a gym, you sign a liability waiver with the gym. If you've gone horseback riding, you've signed a liability waiver, more than likely with all of those. If you bought tickets to an amusement park, you have probably consented to a liability waiver just by paying the fee to come on the property. As I said before, if you go down the rabbit hole with a liability waiver, talk to an attorney to make sure it meets the qualifications. We do have the form one that I'll send to Luke that I forgot to send to him ahead of this that you can utilize, but it's really good to always go back and have the attorney verify that it's actually going to work for your situation. When we put that liability waiver together, I had concerns that it wouldn't meet every qualification in the state as to what people were doing, and it's may not always work, so it's always good to have the attorney review it. As I pointed out, state law changed last year. I think they were looking at fixes to it this year to actually take out some facilities within that, but I'm still not clear where all that's at. But they're really good for businesses to look at within that. I know gyms, equine facilities, pools, and other commercial facilities can't use it. It's not clear in some of this commercial hunting and other ag contexts how useful they still are just based on how the law was written. Okay, then the next part of this is that feeds into all of this idea of negligence is landowner liability. If we've got people coming on the property, landowner liability is just how do we look at it from a negligence standpoint? What duty of care do we owe them by them coming on the property? We're going to really talk about 3 forms of this today, even though I have 4 listed on it, and they go from lowest duty of care to highest duty of care. So with trespassers and bear licensees, under licensees, we're always going to owe the lowest duty of care. They're very similar. With licensee by invitation, we're going to owe a little bit higher duty of care. And then if we have invitees, we're going to owe the highest duty of care. So most of you already know this, what a trespasser is, or anyone who comes on your property without your consent, they remain there without your consent. We have 2 forms in the state. All states have 2 forms of this. We can either have civil trespass, which is a tort violation, or we can have criminal trespass. With civil trespass, there's usually penalties associated with it, damages, other things we can get. With criminal trespass, we're just going to have a criminal statute that puts a criminal fine on them. It may not work in every case. From Maryland, we got 4 types that fit. For the most part, all of you are going to fall under number 1. You're going to have property that has no trespassing signs or meets the DNR regulations, which I believe is still blue paint, with just a blue paint on trees along the perimeter. That signifies no trespassing. If we got ag land, number 4 often applies to, as long as it's cultivated for growing a crop as well. With that, you face at most a $500 fine, and I believe no more than 30 days in jail for the first offense, and it keeps going up. Civil trespass, which is where we got to get at for landowner liability, we're going to have 3 elements we got to show. They exercise some control over your property. That exercise and was done by some physical act or force that can either be stepping on your property, staying there, or putting something on your property. And they did all this without your permission. Again, for the most part, all you get out of this is damages for whatever they tore up or destroyed while they were on your property. With landowner liability, we're looking at what do we have to refrain from doing. All we have to do is refrain from willful and wanton injury. Willful is performed with the actor's actual knowledge, or what the law deems the equivalent of actual knowledge of the peril to be apprehended, or coupled with a conscious unfailure to avert injury. Wanton is extremely dangerous and outrageous in reckless disregard for the rights of others. Facts are going to depend on the facts of each case, but what does this mean in reality? My simple example, which is an actual case, is we had 2 state parks that had a piece of private property in between them. The owner got tired of ATV riders crossing between the 2 state parks to use his property as a way to get there. So he did what he thought was the simplest, smartest idea in the world. He hung a wire that was at chest height for an ATV rider across the trail they used to cross his property, and didn't mark it in any way. What's the one thing he didn't take into account with all this? He didn't start thinking about, height differences, and a child rode across and got hit lower than what, or higher than what he would have expected, and severely injured the child. He no longer owns this piece of property. This is an actual case out of Arkansas. The state now owns this property. He sold it to the state to help settle the case against him. But here is an example of willful and wanton. We're doing something with reckless disregard that we know can hurt others. In our minds, we might not realize it at the time, stringing an unmarked cable, but stringing an unmarked cable that others can't see can create issues. If we had hung, flags up on it, or made it visible, put a sign up that said, hey, beware, low hanging cable when you cross the property, that's probably a little bit better, to where we start putting people on notice that this thing exists. With this, what I always tell people is, in a lot of this, what we're trying to do to refrain from willful and wanton injury is just not do deliberate things that we will know will hurt people. If it's a natural feature of the land, that's not willful and wanton. We're not doing anything to create that natural feature that could create injury. So if there's a rock and they trip over a rock and accidentally hurt themselves, that's not the fault of the landowner. That's their own fault. We refrain from willful and wanton injury. And like I said, bear licensee, same idea in the law, except you're just letting the person on the property, but they're there for their own purpose. So if you're inviting a person on and just tell them they can go hunt, that's a bear licensee. They're there for their own purpose. They're not there to benefit you in any way. We owe them the same duty of care as a trespasser. A lot of this we're getting outside the hunting realm once we start getting into licensee by invitation, although that could be one of these in this too, if they're there for, you set this up for a group of people that you're friends with to go hunting on the property, and they're there As a part of that, they would be a social guest that you've invited on your property now. And your duty of care for them is just to warn them of dangerous conditions. If we're dealing with people going out on for hunting, it would just be, warning them of places within trails they should stay, other areas they should avoid, just because we know from walking across the property where some of the bad spots may be. We may have not seen everything, but we can at least give them a general picture of what would be bad on the property. All we have to do is simply warn them. We don't have to correct anything. We just have to warn. Invitee is where we may get into this if we're leasing it out for hunting, because now they're there for your economic benefit. They're owed the highest duty of care. Basically, we have to protect them from unreasonable risk and keep the property reasonably safe. We're dealing with open land. There's not a lot we can do to help keep them, protect from unreasonable risk other than just warn them again of the bad places that we may not keep people off the property from certain areas where we know there are issues. We know there's a cliff or something where they could fall off, just making them aware of that being on the property. For the most part, we have to do some inspections of the property, make sure we know where the dangerous conditions lie and keep people safe, and just warn them of that. And I say remedy, but that's only really if we're inside a business where we're bringing people in, like a storefront or something like that. We have to remedy it. If it's open land, we just have to warn and try to keep people away from those areas. At any point, we can switch, and these are always fluid situations. If we're in IT and they go outside the bounds of where we expect them to go, so if we have property that's being hunted and we kind of lay out and kind of mark where we want them to go, they go outside those bounds, that makes them either potentially moves them up to trespasser or bear licensee at that point. You may be able to go to a licensee in some of these situations, but it's going to be slightly more difficult. If you invite them into an area where they shouldn't be on the property, that's going to be much more the licensee by invitation and open you up to where you still have to do some ability to keep people safe. I use the example of a store just because it's easier to use that example and get people to think about how to do that. If you move to the back to get something loaded, you're potentially going to become a licensee by invitation at that point, and we're going to have a duty of care. But if we wander outside the bounds of where we're supposed to go in the store, or walk into an employees only area, we're a trespasser at that point. The store doesn't have to protect us. And then recreational use statutes play into all this. Good, I'm doing good on time. I should have enough time to answer questions at the end. So with all this, the idea behind a recreational use statute is, if we think about it, we have a lot of property within most states that if we just opened it up to people to go out in, we have a lot of issues with then having to protect them in certain situations based on just what their status is on that property. The idea was we actually wanted to encourage people to use this property and have people open up private lands to the public so they could take part in whatever benefits there are from being out in open space. The law typically requires, and in almost all states, this is true. What is not considered, what I'm about to talk about with the fee, changes depending on the state. And I can send you to a resource if you're not in Maryland, and you can look at your state law to kind of figure out what that would mean at the end. Typically, we can't charge a fee to utilize this. So if we're leasing the hunting land out, we're charging a fee at this point, and the statute doesn't apply. We can do other things that will potentially not raise to that level, and that will help us in those situations. But the idea is we're going to lower your duty of care whenever you do this. And because none of you can really respond to me because we're on Zoom, if the biggest benefactor of this law is typically governments. Because if we think about it, state parks and federal parks, large open space where people want to go out into, so they get the benefit of this as well, because they're typically not charging you a fee to go out in a state or federal park. And this also lowers their liability at the same time. So once you do this, if you meet the qualifications of the law, we just lower the duty of care to that of a trespasser. So then all we got to do is refrain from willful and wanton injury and not really have to worry about warning people of anything because they're there as a recreational user and they have to qualify for the law. We'll talk about one exception to where what you may be doing may prevent the benefits of this law, but I'll talk about that towards the end of recreational use. Recreational use in Maryland is pretty broadly defined. It can be any type of recreational use we would think of what you would do in public land or land that's out in public space. So hunting, fishing, hiking, canoeing, kayaking, that type of stuff is protected automatically as a recreational use. We have other things that are protected within the state, and this is where it can vary from state to state what a recreational use is considered. But in Maryland, at least, it's farm visits for educational purposes. The university will often utilize farms that they're working with to do pasture walks, crop visits. That's an educational purpose, and the benefit to the landowner is they're qualified under the recreational use statute at that point. Practice judging livestock on a farm, that's considered a recreational use. And anything where Luke would bring people out to look at how woods are being done and some of the research plots he has on private farms and private lands would also qualify because that would be a nature study at that point too as well. The idea is it has to be made free of charge. You can't charge people to come on it, and you can't sell products on the land. Once you start selling anything on the land, we move to another thing. If this was an agritourism workshop, I talk a lot about how this does not actually protect agritourism because we're either charging a fee to come on or we're charging people for products on the farm once it is available. And once that happens, it becomes an invitee. So what's not included in Maryland in a charge? For the most part, you can receive a share of the game, fish, or other products from the recreational use. So if we have people out hunting on the property and they just give us a share of the game in the end, that's what we collect. That doesn't qualify. Anything that's a benefit to the land arising from the recreational use is not considered a charge. As I point out to folks, if you have a lot of deer damage on the property and you're opening it up for permits with hunters to come out just to help control the deer populations, that's a benefit arising to the land because we no longer have deer eating crops. That is not a charge under the recreational use statute, and you can still do it. Contributions in kind or services to promote the management or conservation of land. When I often give this, I ask for a show of hands how many people have been to a state park and seen the box to collect donations out front before you enter the property. That is what that is for, because then they can benefit from you making a donation to help manage that piece of property, and you're not being asked to pay a fee. You can't actually tell people what they have to donate. You can't tell them, normally we expect $25 because that may get up to the fee, charging a fee, but just putting a box out and asking people to make a donation, whatever they feel like giving, helps and doesn't meet the fee requirements. The final thing is the land normally has to be open to the general public and can't be fenced off and you only allowing certain users in. This is a recent case that helped clarify the recreational use statute in Maryland. What we had basically, if I remember right, it was an auto body shop that was fenced off with no trespassing signs all around it, basically keeping the people out. And then behind the auto body shop, the individual had an ATV or motorcycle riding course on it. And then he invited his church group out one Sunday after church for a potluck, and then they could all ride the ATVs around the property. In the course of doing this, one of the users was hurt and severely injured as a part of this. That individual then ended up suing the owner. The owner claimed recreational use. He made the land free of charge. He should be protected. The Maryland Supreme Court said no, he should not be protected because the property was clearly fenced off. It clearly had no trespassing signs on. He only allowed his church group on the property to use it. He never allowed anybody else. So, and this is actually a common thing in most states, that the land actually just can't be closed off to everybody. We actually do have to be letting anyone that wants to come on access it and utilize the property, which can be hard to do when we're trying to keep trespassers off. So there's still some areas where we're trying to figure out how open the land has to be in order to gain the protections in the state. We really only have the one case, so it's not always clear where all that will go in the long run with that. And we're still trying to kind of see where future cases will go. I can do my conclusions and then spend the rest of the time seeing if you guys can stump the chump. So a lot of this is just going to be always a constant concern with, hunting. Like there are certain things, and I'm going to talk about this at the next bullet point, is really just start thinking about what insurance do I need to be covering in a lot of this to help better protect me. So, or if I'm leasing it out for hunting, what insurance policies do I want my leasee to have in all of this? What do I want the tenant to have to make sure that if they get hurt, they have a policy they can come back on and they're at least better protected in a lot of this and can help limit some of this. As I point out, Maryland's a contributory negligence state. If we have insurance with all of this, our insurance company is going to have to, if we get sued, it's going to have to find us a lawyer. They're going to work with us, and more than likely, they're going to figure out a way to settle the case before it even goes to court because insurance companies are more risk averse than anybody else, and they don't want to actually be found that contributory negligence didn't exist in the state. So I have to point out to folks, yes, we have contributory negligence, but you still need insurance to help better protect you. And there's a lot of policies out there that companies have that they can work with you related to hunting to better help limit your liability. Like I said, it's a good way to protect yourselves when we're letting others go out and hunt. We want to have some proof of insurance potentially that they're carrying it, especially if we're leasing it out. We're going to want to be added on as a third-party beneficiary to that policy, just because guess who's going to get sued in all this if they invite a buddy out to go hunt and then that person gets hurt. They're going to sue, may not always sue their buddy, but they're going to sue potentially you as the landowner. So we want to make sure we're covered under a policy that will better protect us in the long run. And then I do a blog at agris.umd.edu. You can follow it there. And then I think if I did everything correctly, I have about 15 minutes for questions.
Perfect timing, Paul. And yeah, you have a number of good questions piling up here. I've been compiling a few resources as well myself that I will post in the chat. I pulled up the Jonathan Kay's publication on this from 2008. So
Yep.
a little bit older, but still something that you can get a sense of. It's probably still pretty relevant.
It probably hasn't changed much
Right.
since 08.
And then I was going to share also an example landowner liability release form that we've been using when we hold management hunts at Point Pleasant Farm. And so we worked with the lawyers at University of Maryland and lawyers with the foundation to get it so it was in good shape. So you can at least use that as a template to work from, and it's been reviewed by our lawyers. So
yeah, and that will probably be a very good release form. That's the other thing I didn't talk about was you can get release forms put in there as well that will greatly help limit a lot of your risk in this.
And we had a couple of people, we'll get to these towards the end, a couple of questions about hunter rules. So do you have, I've included in our example hunter rule forms. They not only have to sign a liability release, they have a rules form that says they'll follow all the applicable state laws. So I shared that for everybody as well.
Yeah, I didn't think about that, but yes, I would have them sign something that says, yes, we know what state laws are related to this. We know what hunter safety is. We're going to follow all of that, and we're going to do everything within the bounds of what we're supposed to be doing as hunters.
Right. Well, let's start at the top. Anthony Antonucci always has great questions for us. Do you think that the thought of deep pockets of the landowner spurs many liability or negligence lawsuits today. How would the courts look at this and make an assessment to determine if this is the primary goal of the action?
And they're really not going to look at the deep pockets part of it. They really are just going to look at, does it meet the qualifications of nuisance or negligence? And, is there an actual negligence case being presented? I think in a lot of cases, a lot of people will look at it and be like, well, the landowner has deep pockets, so they should be sued. I mean, we often look at stuff in law school to look at how are we going to get our clients paid and who is the person that is most likely to have money to pay in the end. So we'll include the landowner in, because if the person was hurt, they're on your land, they're more than likely going to be somebody that's sued. But again, that's why if we're doing the waivers and having them carry insurance and making sure we're added on, we're putting it on their insurance company to get it paid. And then their premiums go up.
Great. Next, Mark asks, great question. On Maryland's Compass website, this is where you buy her hunting licenses, there's a permission to hunt form, and it says in the agreement, in return for the privilege of hunting and or trapping on this private property, I agree to obey the laws and to observe all safety precautions and practices, and to take every precaution against fire and to assume all responsibility and liability for my person and my property while on the landowner's property. So I think that's the full text of the sort of sample landowner permission form. How much is that protecting that landowner?
That's pretty protective, because in the end, that also helps us show contributory negligence, that they knew what they were, and assumption of the risk, that they knew what they were supposed to do. They agreed to follow all the laws and observe everything safety wise that they're supposed to do. And if they don't do that, they're at fault too. And they're more likely not going to recover.
Right. And
Okay,
you
there's
included a link to that form that you can see online and use yourself if you like. All right. Thank you, Mark. Great question. Next is, to what extent do hunt club rules, this got to the point earlier, what extent do hunt club rules help to identify safe procedures and thus imply risky behavior or restrict unsafe practices?
They're really good at laying out what is good behavior, and then anything that doesn't fit within that, we would assume, and I would lay it out too. These are the risky things that we could do. And, we're going to follow whatever state law tells us to do, and we're going to follow, hunter safety while we're out there to help better protect us.
I'm going to go ahead and share my screen, what our rules are that we're using. I'd be interested in hearing your opinion on this, but we can just briefly look at it. But basically, follow the law, know your equipment. We lay out all the documents they have to have in order to hunt, which is a current hunting license, liability form, and sign to these rules. We do a safety briefing before each hunt. And in that safety briefing, we review the 10 commandments of firearm safety. And we also talk about tree stand safety. And then we also have added the hunter orange requirements. We just laid out what the state law is and lay out that expectation, and that they agree to set these all out. And I will note, we have tree stand safety because, and if you're not aware, tree stands accidents are the #1 cause of injury among hunters, not getting shot or shooting others. So that is oftentimes one of the big issues. So that's what we have.
No, that makes sense. And all that lays it out pretty clearly what they're supposed to do. And I like the tree stand safety. Yeah, tree stand safety, because I've seen a number of tree stands that I would not get up in.
I have met too many people who have fallen out of tree stands and broken their backs, and it's really not something you want to do. So I try to be very cautious about that myself. But it's really easy to set something up and not check it every year, and that's how it happens. Several years go by and those straps wear, and the sun wears on them, and they break, and people can fall.
I was just saying that I grew up in Western Oklahoma, where we don't have trees. And they're man-made structures that were camouflaged and put out. And my dad leased farmland. That guy that owned it had a number of tree stands that they went out each year and checked the stands to make sure they were still safe. The poles that were holding it up still were safe.
Yeah. And I always like, if you're going to build something homemade, use treated wood, check it, use a good carpenter, and yeah, just getting up in it and checking it every year is important.
There was no treated wood with all this. It was all metal, and
metal's even better. Yeah. Great. Okay. So I'll hit that answered. If you give permission to a hunter to hunt on your property, and a stray bullet makes it to a neighbor's property, harming individuals, pets, livestock, or buildings, what liability is yours or the hunter's?
The hunter, if I remember correctly, is the one that is liable for this in all situations because they're the one actually out doing it, and the stray bullet is their fault, not really your fault. So yeah, if a pet gets injured or hurt or building or livestock, that's more on the hunter than it is on the actual owner. But I would want that clear within whatever I have the hunter sign, just like if you straight bullet hits a neighboring property and causes damage, it's your fault, not mine.
Yeah. And something that Jonathan Kays always would say, and I'd be curious to hear your take on this, is that anybody can sue anybody. They
Yes.
might not win, but they can always sue you and probably cause a lot of legal costs regardless. Can you elaborate on some of that?
Yeah, and like anything, if somebody gets hurt or has the slightest wrong done to them, they're gonna sue and want to do it. I go back to my auto accident example when I called my dad right after a farmer in Oklahoma, his first words to me, well, you're gonna sue, right? You should sue in that situation. I'm like, why would I sue? There was no damage. And like, that's a bigger waste of my time to sue this individual than me. And she was a nice person. So why would I? She seemed to be nice that day. So why would I sue her? But yeah, anybody can sue. It's just whether or not the court will actually believe that you have a case. And yeah, you're gonna have to fight that out, get lawyers, and it's just a pain in the butt to have to deal with.
Are there some ways what are some ways to protect yourself from that situation? You might have a airtight case, but how can you do insurance policies? I know some insurance policies can help cover legal costs for things like this up to a certain amount. Is that
Yeah, that's the best
strategies
way
you use?
because all insurance carries, at least liability insurance carries a duty to defend. So the insurance will have to you'll have to make your insurance company aware, and then they'll work with you to get an attorney. And it's probably somebody they used before that knows how to handle this. And that's the easiest way to help this go away is just having insurance and making the insurance company aware whenever it happens. I've yet to make my auto accident insurance aware that I was in an auto accident because I just didn't want to have to deal with the stupidity.
Yeah. And
Still,
there are several resources available for hunting liability insurance as well. And so that's that publication we put out has several resources, but you can do some Google searches and find people who will cover you. I think it's not too expensive. And you can also ask the hunters to purchase it. And as you said, add you as a third party beneficiary.
yep.
Good to know.
Yeah, I would always have myself added on, especially if I'm leasing it as a third party beneficiary, because they're going to sue me too as the landowner. So it's just easier to use their insurance than
Yeah.
use mine and create more hassles.
Yeah. We had another question on requirements for rules, what's allowed and what's not. If so, is there a template for such a document? I just shared that. Or is an attorney suggested to create one? There's an added twist to that one. Do you recommend an attorney, looking at those rules as well?
Yeah, just to make sure, because if they've dealt with this before, they may have other ideas and they may think of something that can come into play that can help in that situation.
Anthony asked a couple more here. This is a little bit different, but interesting to think about. With the federal push to establish conceal and carry laws on a national level and usurp state laws, how would such a law play into what has been presented? As a landowner, can you impose carry restrictions on your property?
Yes, you can. Luke probably knows this from working on the Y, and I work on campus. If concealed weapons are not allowed because our employer does not allow us to carry concealed weapons, even if state law allows concealed weapons, you as the property owner can set it. I mean, we can look at like most of the stores we go into probably have signage up now that say concealed weapons are not allowed in the facility. So you can set up rules and restrictions that say what you will allow on the property and what you will not allow on the property. Oh, and Anthony has more questions.
Yeah, he raised his hand. So Anthony, I've given you permission to speak. If you want to unmute yourself, you can come on live and ask your question. Otherwise, I see we have another follow-up question from you. Are there any
Yeah, I just put
considerations?
the question in
Go ahead.
instead, so you can read it.
Yeah. Are there any issues or considerations that would apply or exempt you when law enforcement, first responders, or other similar individuals enter your property? they are allowed to carry their concealed.
Yeah,
or-
they're allowed. Yeah, you can't stop them, but anyone else you can stop. Yeah, because they have a right as those within those jobs to do that.
Does that work for you, Anthony?
Yeah, that's fine.
Cool. And then we had one final one. Do we have an example of a sign you can post on a farm, like warning that farming is dangerous or enter at your own risk? There might be some standard no trespassing signs in that liability release document. But do you have any thoughts on signage?
On signage, if you go, and I haven't looked in Tractor Supply for a while, but most of the signage in Tractor Supply will help you. You can look online. I believe at one point Maryland Farm Bureau had signage that would actually work, because I remember it was before COVID, so I remember talking to Parker Colby about that at one point when Colby was still here, because they were working on signage that farms could put up that kind of highlighted it was dangerous and some of the things that can come up. But yeah, usually signage is pretty good. We didn't go over this because I didn't have to talk about dogs today. Most signage is not making anybody aware other than there is this known condition on the property. So as long as you can find something that kind of highlights what your concerns are about your farm and what you're doing, that should usually work. And it's not going to increase your liability. It just makes the general public aware if they come on your property, it is something they have to watch out for. Beware of dogs. Never tell people that you have a dangerous dog. They just warn people there's a dog on the property. So
Interesting.
same idea with other things.
All right. I had a couple others come in. Let me jump down to John Sprinkle here. We own both sides of a creek, which is frequently used by kayakers. Do I have any liability regarding recreational use?
John's in Delaware, correct? If I remember from your presentation last night.
I don't know where John Sprinkle is based. John,
So I can describe this to the best ability, and I need another lawyer here who usually answers this question for me. Kent County, Maryland. Okay, so if with kayakers, they have the right to come on the property through the natural flow and up to where within that high water mark on the property. You have no liability typically because they're coming on as a part of the public right to go through the creek or the river. If they go outside the bounds of that, they're a trespasser and your liability is pretty limited.
gotcha.
Most of that's going to fall under recreational use, so it should be pretty low. But yeah, with kayakers, especially if it's a waters of the state, they still have some rights. But I need Tony Gorski here when I do that one because I usually put that on Tony.
Teresa said it used to be or may still be the mean high tide mark, but I would think,
That's the word I'm looking for, mean high tide mark.
right. What about on freshwater rivers or creeks that are above that are non-tidal that you could kayak? Those are,
They have a right they basically have to stay within the stream up until, and I forget how far it is past that. It's not much though.
right.
As long as they're staying within the stream, and most of them are usually going to stay on the stream unless they have to get off.
If they are trespassers, what is the liability requirement? So you would only be negligent if you had something with willful and wanton
Hurt them. Yeah.
risks that would harm them. A
Yes.
reasonable person would find would be harmful.
Yeah. You can't put stuff up along the bank that would hurt them, but
Like,
as long as if they're walking on it and they hurt themselves, that's not your fault. They should have stayed on the kayak or the canoe.
well, gosh, look at this. You did it perfect. It is 1 o'clock. We've gotten through all the questions. There's one last one. John asked, so we didn't have to put up any signs. I think that's looks pretty clear. One final
Yeah.
one. Anthony asked, but we're right at one, perfect timing. Are there any 3-strike rules where if a thing happens on your property too often, that localities, law enforcement, or state environmental agencies can impose restrictions on your property or outright banning of activities?
I'm not aware of any. I'm not aware of any.
Right. Yeah, I'm not either. Great. I think that covers everything. We have some thank yous for sharing. I appreciate you sharing, Paul. This idea came to us in our evaluation survey. So as you leave, if you have any ideas, somebody mentioned to me, they said it's talks like this has been helpful for them to share with landowners to help gain permission to hunt. So hope this is helpful for some folks, and I look forward. Thank you for joining us, Paul.
No problem. Thank you for inviting me.
Yeah, I look forward to seeing everybody next month. This will go up on YouTube and we'll post up there soon so you can share it with others.
Cool. Have a good afternoon, everybody.
Yeah, everybody take care. Bye.
Bye.